Do the states have the right to ban gender-affirming care for minors? That's the question the Supreme Court will start pondering tomorrow, and the decision the justices make will have huge implications, not just for those minors, but for the entire trans community, and will test the Constitution's equal protection guarantee. Tomorrow, the justices will hear the case of United States versus Skrmetti. Skrmetti is Jonathan Skrmetti, the Attorney General of the state of Tennessee. Last year, Tennessee's legislature passed Senate Bill 1, which prohibits all medical treatments intended to allow a minor to identify with or live as a purported identity inconsistent with the minor's sex, and bans medical professionals from treating purported discomfort or distress from a discordance between the minor's sex and asserted identity. Basically, this law bans doctors from providing medical care like puberty blockers, hormones, or surgeries to transgendered people under the age of 18. The Biden administration and 3 transgender teenagers and their parents sued, saying this law is unconstitutional and it is a violation of the 14th Amendment's Equal Protection Clause, and they wanted the courts to step in. Well, the Sixth Circuit Court of Appeals did, and ruled against them, saying the law does not discriminate based on sex, and the court allowed the law in Tennessee to take effect. The Department of Justice appealed to the Supreme Court, and tomorrow the justices will hear those oral arguments. Now, it's worth noting one of the lawyers representing the families is the first openly trans attorney to ever argue in front of the Supreme Court. So, what are they going to argue? Well, not only does the Biden administration argue the law is unconstitutional, but on top of that, they say it's discriminatory. They argue the law allows for a teenager whose sex was assigned male at birth to be prescribed testosterone to conform to a male gender identity, but does not allow a teenager assigned female at birth to have that same prescription. DOJ's appeal also goes through the real medical repercussions of not allowing someone who is transgender to be properly treated, and also argues that these gender-affirming treatments aren't just given out willy-nilly. They require comprehensive assessment to ensure any intervention is medically necessary. DOJ says not treating someone who is in desperate need of intervention can cause serious other problems: psychological harm, depression, substance abuse, and suicide. For the record, Tennessee is not the only state with a law like this. There are about 24 other states with similar laws. Some have been blocked by other courts. Now, the Tennessee lawmakers who support this bill call these types of treatments barbaric, saying these treatments should be stopped because they have unproven benefits and lifelong harms. For his part, the Attorney General of Tennessee has been defending the law since it was enacted in 2023, saying, "We fought hard to defend Tennessee's law protecting kids from irreversible gender treatments and secured a thoughtful and well-reasoned opinion from the Sixth Circuit. I look forward to finishing the fight in the United States Supreme Court. This case will bring much-needed clarity to whether the Constitution contains special protections for gender identity." The AG of Tennessee is right. The way the justices rule on this case will have massive implications for gender identity protections under the Constitution. And depending on which way the Supreme Court goes, their ruling could open the door for more laws to be passed blocking gender-affirming care, even for adults. A ruling is likely not going to come down until the summer of 2025.